This week, the 11th Circuit blew a big hole right in the middle of the so-called Barton doctrine. Although, as a matter of policy, personally speaking, I don't like the result, but, again, as a matter of personal opinion, I happen to think that the 11th Circuit made the right decision on the law. The Barton doctrine comes from 1881 and the U.S. Supreme Court in a case called Barton versus Barber. As I said, that's 1881, not 1981. It was then, 140 years ago, the Supreme Court said that you cannot sue a receiver without the permission of the court that appointed the receiver. When the Bankruptcy Act was later adopted, well, the Barton doctrine was extended to bankruptcy trustees and later to virtually all retained professionals in bankruptcy cases, including also creditors' committees. The 11th Circuit, 8 months ago, had an opinion that chipped away at the Barton doctrine, and this week they blew the hole wide open. The 11th Circuit explained that the Barton doctrine was based on the notion that the receiver court or the bankruptcy court had exclusive jurisdiction over the property of the estate, and therefore another court couldn't mess with it while the receivership or the bankruptcy was still alive. However, in this brand new case this week, the 11th Circuit says that when the bankruptcy is over and all of the bankrupt property has disappeared, shall we say, there is no longer any exclusive jurisdiction in the bankruptcy court, and therefore a disgruntled creditor or whomever it is can sue the trustee wherever that creditor can find personal jurisdiction. Well, as I said, I don't like the result as a matter of policy because, this is going to scare trustees and receivers because after their cases are over, they can get sued in a court that is not familiar with the bankruptcy or the receivership. But I think I have to agree with the 11th Circuit because under 28 U.S.C. 1334, there is exclusive jurisdiction in the bankruptcy court only for the case and not for other actions such as, actions that are related to, which is going to be what the situation is when a trustee or a receiver is sued after the case is over. But, as I said, although I don't like the particular policy, I think maybe there is a way to achieve the same result. So try this on for size. Let's assume that a trustee or a creditors committee or whomever is sued in some court, a state court somewhere, after the bankruptcy is over. Well, tell you what, why doesn't the trustee or the committee or whomever it is reopen the bankruptcy case, then remove that suit to federal court, and then ask the federal court to send that case, refer it to the bankruptcy court. When that happens, that disgruntled creditor or whomever it is going to be right back in front of the bankruptcy judge who was very familiar with the entire case. And in those circumstances, I suspect that, that recalcitrant creditor is going to either back off or quickly get flushed down the drain by the bankruptcy court. I am Bill Rochelle, the editor-at-large for American Bankruptcy Institute. You can read about this very interesting case in the 11th Circuit in my column on the ABI website, which comes out today. Well, tell you what, that's what we have for now. I will be back same time next week with something interesting in the world of bankruptcy. Until then, be well. Good day.